Minnesota has one of the most heavily regulated tenant screening environments in the Midwest, and the regulatory landscape has become significantly more restrictive in recent years. The governing framework includes the Minnesota Residential Tenant Act, found in Minnesota Statutes Chapter 504B, along with the Minnesota Human Rights Act, FCRA, and an increasingly active set of local ordinances in Minneapolis and St. Paul. If you're screening tenants in Minnesota, you need to understand a complex and evolving regulatory framework. Let's start with application fees. Minnesota has specific statutory provisions governing screening fees. Under Section 504B.173, landlords can charge a screening fee, but the fee is subject to limitations. The landlord cannot charge a screening fee if the landlord knows or should know that no rental unit is available at that time or will be available within a reasonable time. This prevents landlords from collecting fees when there's no realistic prospect of renting to the applicant. Minnesota also requires that before collecting a screening fee, the landlord must provide the applicant with specific information, including the screening criteria, the name and address of the screening service being used, and a disclosure of the applicant's rights. If the landlord doesn't provide this information before collecting the fee must be refunded. The fee itself must be limited to the landlord's actual cost of screening. The landlord cannot charge more than what the screening service charges. If the landlord uses an in-house screening process, the fee must be reasonable and limited to actual costs. Additionally, Minnesota requires that if the landlord rejects the applicant, the landlord must provide written notification of the reasons for the rejection within 14 days of the rejection. This notification requirement goes beyond FCRA's standard adverse action notice and ensures that applicants receive a prompt, specific explanation of why they were denied. Criminal history screening in Minnesota has been significantly affected by recent legislative action. Minnesota enacted a statewide ban-the-box housing law that restricts how landlords can use criminal history in screening decisions. Under the law, landlords cannot inquire about or consider criminal history until after the applicant has been provided the terms and conditions of the tenancy, including the rent amount and other lease terms. This sequencing requirement means that criminal history cannot be the first thing a landlord evaluates. The applicant must first understand what they're applying for. Minnesota restricts the types of criminal records landlords can consider. Landlords cannot consider arrest records that did not result in conviction. Landlords cannot consider expunged or sealed records. Landlords cannot consider juvenile records. And landlords are subject to look-back period limitations that restrict how far back they can consider criminal convictions, with the specific look-back period depending on the type of offense. When a landlord does consider criminal history, an individualized assessment is required. The assessment must evaluate the nature and severity of the offense, the time elapsed since the conviction, evidence of rehabilitation, and the direct relationship between the criminal conduct and the tenancy. The landlord must consider any supplemental information the applicant provides. If the landlord denies the application based on criminal history, the landlord must provide written notice that identifies the specific criminal record and explains the reason for the denial. The applicant must be given an opportunity to dispute the accuracy of the record and provide additional information before the landlord makes a final decision. Minneapolis and St. Paul have enacted even more restrictive local screening ordinances that add requirements beyond state law. Minneapolis enacted a comprehensive tenant screening ordinance, the Renters' Rights Ordinance, that restricts criminal history screening, limits how credit history can be used, and imposes additional procedural requirements. Under the Minneapolis Ordinance, landlords face restrictions on using credit scores as a sole basis for denial, must consider the applicant's overall financial picture rather than relying on a single credit metric, and must follow specific procedures when considering criminal history. St. Paul has similarly enacted tenant protection measures that affect screening practices. Landlords in St. Paul should review the city's current ordinances for specific requirements. HUD's 2016 guidance on criminal history and disparate impact applies in Minnesota. The state's diverse population, particularly in the Twin Cities metro, which has significant African American, Somali, Hmong, and Latino communities, means that criminal history policies face heightened scrutiny. Minnesota's enforcement environment is active, and fair housing organizations regularly file complaints and pursue litigation. Source of income protection in Minnesota is well established and strongly enforced. Under the Minnesota Human Rights Act, Section 363A.09, landlords cannot discriminate against applicants based on their status with regard to public assistance. This includes housing choice vouchers, Social Security, disability payments, supplemental security income, Minnesota Family Investment Program benefits, and any other lawful source of income. Minnesota's source of income protection is one of the broadest in the Midwest. Landlords cannot reject applicants because they receive a housing voucher. Landlords cannot advertise that they don't accept vouchers or government assistance. And landlords cannot set income requirements that effectively screen out voucher holders when the voucher plus the tenant's income would cover the rent. The Minnesota Department of Human Rights actively investigates source of income discrimination complaints. Fair housing testing occurs regularly in the Twin Cities metro. Organizations send testers posing as voucher holders to identify discriminatory practices. Landlords who make statements suggesting they don't accept vouchers face enforcement action. Minneapolis has enacted additional protections beyond the state source of income framework, and St. Paul's local ordinances provide similar coverage. Landlords in both cities should treat the local requirements as their compliance baseline. For credit reports, Minnesota follows FCRA requirements plus the state's additional provisions. The screening fee disclosure, the 14-day rejection notification requirement, and the individualized assessment framework all add layers beyond the federal baseline. Minneapolis's Renters' Rights Ordinance specifically addresses credit screening, restricting the use of credit scores as a blanket denial criterion and requiring landlords to evaluate the applicant's overall financial situation. This means that a Minneapolis landlord cannot simply set a minimum credit score and reject everyone below it. The landlord must consider additional factors including income stability, rental payment history, and explanations for credit issues. Minnesota's fair housing protections under the Minnesota Human Rights Act, found in Chapter 363A, are among the broadest in the Midwest. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, age, and status with regard to public assistance. The breadth of these protections, particularly the inclusion of sexual orientation, gender identity, and public assistance status, creates a screening environment that requires careful attention to every aspect of the process. Minnesota also has specific protections for victims of domestic violence, sexual assault, and stalking. Under Section 504B.206, landlords cannot penalize tenants or applicants based on their status as victims. In the screening context, landlords cannot deny an application because the applicant has a history of being a victim of domestic violence or because incidents at a prior tenancy were attributable to the perpetrator. From a practical standpoint, Minnesota's rental market is concentrated heavily in the Twin Cities metro, with secondary markets scattered across the state. Minneapolis and St. Paul together form one of the strongest rental markets in the Midwest. The Twin Cities economy is driven by healthcare, including Mayo Clinic's growing Twin Cities presence, Allina Health, Health Partners, and Fairview, corporate headquarters, Target, United Health Group, 3M, General Mills, Best Buy, and U.S. Bancorp, among many others, technology, financial services, higher education. The University of Minnesota is one of the largest universities in the country, and government. The Twin Cities have consistently low unemployment, high incomes relative to cost of living, and strong rental demand. Minneapolis has the most restrictive screening environment in Minnesota due to the Renters' Rights Ordinance. The ordinance's restrictions on criminal history screening, credit score usage, and procedural requirements create a screening process that's fundamentally different from what's permitted elsewhere in the state. Landlords in Minneapolis must build their entire screening workflow around the ordinance's requirements. St. Paul enacted a 3% rent cap, one of the strictest in the country, which affects the rental market dynamics and has implications for the screening context. The rent cap means landlords have limited ability to adjust pricing, making tenant selection through thorough screening even more important. You can't easily recover from a bad tenant by raising rent on the next one. The Twin Cities suburbs, including Bloomington, Eden Prairie, Plymouth, Maple Grove, Eagan, Burnsville, and Woodbury, have strong rental markets driven by corporate employment and suburban lifestyle appeal. These communities generally operate under state law rather than the Minneapolis or St. Paul local ordinances, but the state-level requirements are still substantial. Rochester, home to Mayo Clinic, has an extremely strong rental market driven almost entirely by the world's leading medical institution. Mayo Clinic employees, patients seeking extended treatment, and the supporting healthcare ecosystem create consistent, high-quality rental demand. Rochester's applicant pool tends to be well-qualified with strong credit and income profiles. St. Cloud has a moderate market driven by healthcare, higher education, St. Cloud State University, and manufacturing. Duluth has a market influenced by healthcare, Essentia Health and St. Luke's, the University of Minnesota Duluth, tourism, and the Port of Duluth. Mankato, Moorhead, and Winona have smaller markets with university influences. The Twin Cities' diverse immigrant communities create important screening dynamics. Minnesota has one of the largest Somali populations outside of Africa, concentrated primarily in Minneapolis. The state also has significant Hmong, Karen, Oromo, and Latino communities. Screening applicants from these communities may involve evaluating non-traditional income sources, limited U.S. credit history, and unfamiliar rental backgrounds. Having clear, documented criteria for evaluating applicants with limited credit files, including accepting co-signers, considering alternative creditworthiness indicators, and evaluating income from multiple household members where appropriate, ensures fair treatment while maintaining screening standards. Military presence in Minnesota is relatively limited. The Minnesota National Guard has facilities throughout the state, but there are no major active duty installations generating significant rental demand. One critical best practice for Minnesota landlords: invest the time to understand and implement the state's screening notification requirements. You must provide screening criteria disclosures before collecting a fee and must provide written rejection reasons within 14 days. Build these requirements into your workflow with standardized forms and timelines. Missing the 14-day notification deadline is a straightforward compliance violation that's easy to avoid with proper systems. Another critical best practice: for Minneapolis landlords specifically, restructure your screening process around the Renters' Rights Ordinance. You cannot rely solely on credit scores. You must conduct individualized assessments for criminal history, and you must follow specific procedural requirements at each stage. The safest approach is to work with a Minnesota landlord-tenant attorney to build a compliant screening process. The ordinance's requirements are detailed enough that a do-it-yourself approach creates significant compliance risk. A third best practice: never state in any form that you don't accept vouchers or public assistance. Minnesota's source of income protection is actively tested and enforced statewide. Remove any language from listings, websites, or policies that suggests you don't accept government assistance. Train everyone who handles inquiries or applications: leasing agents, property managers, maintenance staff, administrative personnel. That source of income discrimination is illegal in Minnesota. Minnesota limits the security deposit to 1 month's rent for most tenancies. The deposit must be returned within 21 days of the tenant vacating, along with an itemized statement of deductions. Interest must be paid on deposits held for more than 5 months, at 1% simple interest per year. The limited deposit combined with Minnesota's extensive screening restrictions makes compliant, thorough screening your most critical tool for tenant selection. For the complete guide to Minnesota tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.